Yes, ma'am, to the best of my knowledge.
Okay.
Is
that,
he
yeah.
still
I object
able?
to that, Your Honor. I'm not allowed
Sir,
to
her
keep.
answer stands. There's no question to which to
I
object.
object to that. There is.
You can't testify at the moment. If you want to provide further information after she is done testifying, I will give you that opportunity.
Will she?
Your
will she be
objection
able to-
is
Will she
overruled.
be able to stay right there so I can ask the question?
It's not your time yet. You have to wait. So this is the final warning. Okay, I've given you a lot of leeway today.
You have not, Your Honor. You haven't. No.
I
you
am
haven't.
turning to Attorney Opper. It is her opportunity, her turn to ask this witness a question.
And it is my right to be able to object, just like she objected
And-
when I was asked the
Right,
question.
and when the court rules on an objection, usually the party who objects stays silent. I rule on the objection. The parties don't debate the ruling. It's noted for appeal. And then we move on.
Then I would like to put you on notice that I will be appealing that judicial decision that you are making.
Next question, Attorney Opper.
The judicial determination.
Ms.
rather,
Molenhop.
that you are making.
While on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses. Is that correct?
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Yes, ma'am.
And nothing about the protocol would restrict his access to any of those materials. Is that correct?
Correct, ma'am.
And you've
I object to
indicated
that. I
previously.
object to that respectfully, Your Honor.
So, an objection goes to whether there's lots of rules of evidence that
That's it.
apply. But if you're objecting to her answer, that's a different thing. You can argue
I'm
the meaning
objecting
of
to
that
the
later.
question,
Okay,
not
the
the
objection.
answer.
But then you have to say objection before she answers. You
She
objected
didn't
after
answer.
she
She
answered.
didn't answer the last
The
question.
objection is noted, it's overruled, her answer may stand. Next question.
Ms. Wollenhop, you're aware that there has been digital discovery made available to Mr. Brooks for him to view in the Waukesha County Jail,
I
correct?
respectfully object to that.
Overruled, she may answer. Correct.
He would view that digital discovery on the computer in the conference room in his pod,
I
correct?
respectfully object to that.
Overruled, you may answer. Correct, ma'am.
And
So you're gonna
the
overrule
proto-
everything, Your Honor?
All right, Mr. Brooks, you have got to stop. It's fine if you object. I will rule on it as I deem appropriate under the rules of evidence, which, by the way, I provided a copy for you. See that big book over there?
No, I don't
It
see
has
it.
the criminal statutes.
I don't see it.
It has the traffic code. It
I
has
don't
the
see
rules
it.
of evidence. Well, it's on your table. It's
I
behind the
don't-
microphone, and it's there. I've provided it to you as a courtesy so that you have that available
You did not
to
provide
you.
anything to me.
Right, I'm
Something
directing the
that-
bailiffs to
something
remove
that
him
may
to the
have-
other courtroom.
something
I've
that-
provided ample opportunity
I've
for
never-
Mr.
I've
Brooks
never
to
taken
abide by the
anything-
simple
I've
rules
never
of
taken
decorum
anything,
and
Your Honor.
civility.
Your Honor, I don't
He is-
consent or agree to what you are doing.
Your lack of
don't give
consent is
consent.
noted for the
I
record.
don't give consent to an estoppel. I don't give
I'll make a
consent.
more full record when we
I
are
don't
open
give consent
again to
an
the public.
estoppel. I don't give consent to be removed.
Madam Reporter,
being
the
able
record
to
should
exercise
reflect
my
the court is
constitutional
stepping
right.
off the bench. You may step off
I
if you
move.
want.
I move for a motion to dismiss. You still haven't even ruled on the claim. There's no one that even has a claim against me here.
All right, we are back on the record. Appearances are as they were before. I need to make a record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. On every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case. I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items. I want to give him headphones since he has claimed in the past to be hard of hearing in one ear, but given his statement that he would throw and break things, unless he can pledge to this court that he will not do that, I'm not going to provide that information. I will advise that the audio in that courtroom should be turned up accordingly so that it is louder than it has been. I've also been advised that the audio and visual equipment is working in that courtroom. The deputies that are in there can see and hear the court through the Polycom system. Today is a little bit different in that there is no Zoom. And so, but this court, with the blessing of technology in this new building, have the ability to call in one room system to the other. That is why we're able to see and, when appropriately, hear him when unmuted. And then there are the 4 camera angles that are presently from this courtroom. I have the camera in the other courtroom on a single camera since he's the only individual in there. This court has, in essence, extended this courtroom to the neighboring courtroom. While there is ample evidence in the record, not only through the proceedings up to this point, but this morning alone, that through his conduct, he has forfeited his right to be present. I'd also make a finding that he is appearing from that courtroom, and that because of the audio and visual equipment and system that we have in place, that it is the functional equivalent of being present in this courtroom. This court has relied repeatedly on Illinois versus Allen. I've read portions of that case into the record. I don't intend to go through that at length here today, other than to indicate that trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula exists for maintaining the appropriate courtroom atmosphere will be best in all situations. And in that case, there were at least 3 constitutionally permissible ways for a trial judge to handle a stubbornly defiant defendant, which this court would find Mr. Brooks squarely has become and has demonstrated over the course of these last few days. One option is to bind and gag him. I've already talked about at a previous hearing why I choose not to do that. Cite him for contempt. I choose not to do that either. The third is to take him out of the courtroom until he promises to conduct himself properly. Mr. Brooks today, of course, showed up in court from the jail in his jail attire. He does that by his choice. I gave him the opportunity to go back to the jail to put on his suit and tie or other street clothes. He refused to answer that question. This court will continue with this trial, as I have previously indicated. There are many resources that have been put into bringing this day to bear, and it is important for all involved that this trial continue. Again, Mr. Brooks is given the opportunity to appear from that other courtroom. At this point, I'm still in the final housekeeping matters, and so he clearly has forfeited his right to be present for that. I will advise Mr. Brooks, as I have advised him repeatedly, if at any point in time he wants to come back, and he is willing to promise that he will abide by the rules of courtesy and decorum and be civil and show respect for the court proceedings for all individuals in this courtroom, including Mr. Brooks himself, then he may come back in. It's also my intention to give him that opportunity at each new stage. But again, we are in the preliminary stage prior to the jury being brought in. I would note it's a little after 9:06 a.m.
And that's referring to this quote-unquote jury view?
Yes. Thank you.
I accept for value in return for value this document. And I would like the record to reflect I still haven't received my original copies of my filings here this morning with the timestamp.
Let me know when you've had an opportunity to review it if you so choose.
I just stated for the record, I accept for value in return for value the document.
Do you have any position on this state's proposal?
I'm still trying to understand the whole process.
Mr. Brooks, my question to you is, do you have any position on the state's proposed jury instruction? Otherwise, I'm going to rule on their request.
You're gonna rule on the request anyway. I got a lot of questions that don't get answered.
I have to rule on the request, sir. It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
Yes, I have.
No, you
In
haven't.
any event, do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
One last time, Mr. Brooks, do you have a position on
Can
the
I
state's
go over the
proposed-
document, please? Can I do that, Your Honor? Respectfully,
sorry?
for the record, may I do that? You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes? 'Cause
Reference
it's
to
the same.
the-
It's the same document. That was
Reference to
accepted for value,
the-
returned for value yesterday. The same document.
It's not the same. The changes were put on the record verbally by the state. It's taking out reference to Sallyport of the Waukesha County Jail, referring to it simply as a garage attached to the Waukesha County Courthouse. Those would be in the first two paragraphs. I believe the rest is the same.
So it was a couple words changed.
That's my understanding.
So it's the same document.
Let me know when you're finished reviewing it, and
I
I'll have a
don't
question.
have to review the same document that was reviewed yesterday, accepted for value and returned for value yesterday.
All right, then let me ask you this, sir. Do you have a position on the proposed instruction from the state?
it's essentially the same document. What was the significance of the change? What's the significance? Garage, Sallyport. What is the relevancy of what it's called?
State want to put on the record again the basis for the change deemed appropriate. Here you go, Madam Clerk.
I want to say to that too, in reference to that, I actually said on record numerous times that I wanted the original copies of all my filings. I've actually said that 3 times on the record. This would be the 4th time. Every filing that
I'm going to give it back to you, sir, but I'm not required to by law.
Well, I'm just saying on record that I've asked for that numerous times.
Your statement's noted for the record. All right.
So would I be able to get all the original copies of all my filings?
I'm not going to address that any further, sir, because I am not the official keeper of the record. As to what was filed this morning, as a courtesy, we will provide you back with the original once it's scanned and it's in my electronic file.
I was told that you make the decision if I can get the original copy.
And I just made a determination you could have the original back of this
Can
one.
I have the originals for all my filings?
I'm not going to address that right now, sir. I don't have time, frankly, to look through everything that you filed to determine whether we've given you originals or not. In the future,
I have the copies. I don't have the originals.
All right, I'm going to move on.
I have
sir.
them here.
This is taking up valuable time with the jury. We need to keep going.
Is that a judicial determination, Your Honor, that I can't get an answer to
I
something?
don't believe there's any other preliminary issues we need to address unless the parties have anything from the state.
Just very briefly, Your Honor, to advise the court, I have 4 witnesses here that I believe are very brief records custodian type witnesses on some video evidence. I'm hoping my direct should take 5 to 10 minutes for each of them. And then I have 2 police officers who will be testifying. There will be some physical evidence involved when those officers testify. And Detective Casey went to retrieve it and he will bring it to the courtroom. When that moment comes, do you want me to have Detective Reglan take the exhibits to the witness stand, or what is the court's direction on that?
I would like you to provide it to the Sheriff's Department bailiff who's in the courtroom, my bailiff, who will then take it to the witness stand.
Okay, Deputy Bordeaux and... Yes, okay, I understand. Thank you.
All right, thank you for the roadmap for today, if you will. Anything preliminary other than the filing, sir, and other than the topics we've discussed this morning?
Yeah, I'm still wondering when I will get the copies back for the ICFs that I filed.
I can't answer that. I don't have those, sir. You'll have to reach out to Clerk of Court Monica Paz.
Well, what happened to them?
I don't know. They're not part of the record. So you'll
They
have to
should
take
be.
that up with her by an inmate communication form and ask her for those. But I'm not going to address that any further on the record. All right, let's
should
bring the
be.
jury up.
It's kind of funny that they disappeared. No,
That
ICF
assumes a
disappeared
fact,
before.
Not an evidence, sir. So
They haven't disappeared before. I've always got copies. What's the difference now?
All rise for the jury.
So I have to readdress her the same thing in order to get copies that I've always been getting since the beginning of you telling me to file ICF.
Sir, as a courtesy, if you want to make a list of whatever documents you believe you have not been provided copies with, I will, as a courtesy, instruct my clerk, Teresa. They're not going to be dates or timestamps other than what's in the file. They'll be from the electronic file, but you need to provide her with a list, and then I will do that as a courtesy to you. But I'm not required to do that. But as a courtesy, I will do that. And as far as any ICFs, if they weren't directed to me, then you will have to follow up with Clerk of Court Monica Paz. I don't have them. They're not part of the file.
Then why were you getting them before?
You'll have to ask her that.
I have to ask her why you were getting them before?
My understanding is they were forwarded to me, sir, but
So what happened to this one being forwarded to you?
Sir, I can't answer that. I can't answer what I don't know. So
It
the
seems
jury's
like you're
coming
trying to
in. We're
avoid
going to
it. That's
we're
what
going
it
to
seems
continue
like.
with the trial. So thank
Just
you.
like you've avoided subject matter jurisdiction. You haven't proven that on the record.
Thank you, everyone. Please be seated. And thank you for your patience this morning as the court addressed some legal issues with the parties. That I cannot physically fit in this courtroom. It's too big. There's no way to get it in.
Okay, I'm informed of that, but at the same time, if I haven't signed any waiver, how could it be lawful? I haven't given consent or agreement to a jury view. I haven't waived any right. When the whole issue was brought up, on the record yesterday, my first thing that I said was, I don't see the relevancy of why there should even be a jury view. And that was the whole issue. And yesterday I was told about I don't know how you say it, the colloquy or however you say it. I don't know how to pronounce it.
I know what I said, and I'm
Yeah.
telling you I had time to reflect. That was my initial reaction to your statement yesterday, but I've thought about it some more and I'm changing my mind. I don't believe I need to take a full waiver with a colloquy with you and anything in writing. I'm advising you, you have the absolute right to be there. But I'm also advising you that if you choose not to be there, I will honor that request. And I'm not going to force you. I'm not going to direct the sheriff's department to, use any type of force, if you will, or require you or get you there without your consent. You either cooperate with that process or you don't.
The way I interpret the law, though, Your Honor, which the law is designed to be interpreted by the people. The way I interpret that is I have the right or essentially to be there or not to be there, and it still has to be an agreement or consent. That's how I interpret the law.
My ruling on that, sir, is I disagree with you. You do not need to provide consent for the jury view to happen. Your objection is noted for the record. I'll make a specific finding today that it is relevant to these proceedings, to this trial. There is an allegation that you drove through the Waukesha Christmas Parade on November 21 of 2021, driving a red Ford Escape, killing 6 and injuring dozens more. The relevance is that there is, in addition to the charges, there's an enhancer that has been charged as it relates to the intentional homicide charges and the first-degree recklessly endangering safety, that you committed those acts while using a dangerous weapon. I would direct your attention to the meaning of a dangerous weapon, that the legal definition that was provided to the jurors in the preliminary jury instructions, and that the jury view is related to the evidence that the state is presenting regarding the charges, and specifically the instrumentality that they allege is the dangerous weapon. So there's clear relevance of this vehicle and has evidentiary value. Again, your objection is noted for the record, but I will and am permitting the jury view of the vehicle. With that, I'm going to move on to the jury instruction.
I don't agree or consent to that, Your Honor.
I understand your objection is well noted for the record. I need to keep going though on the pattern and jury.
I'm informed that you need to keep going. I'm not trying to stop you from continuing to go. I'm merely stating for the record that there are things I do not understand how they're being permitted versus the Constitution. I mean, I'm sure you're aware under Article 6, Chapter 2 about the Supremacy Clause, that the Constitution is the supreme law of the land. So how can we disregard?
Mr. Brooks, I'm not disregarding the Constitution. Here's the thing, I've made my ruling, okay? Once I've made a ruling, I do expect that even if you disagree with it, you will not continue to argue it.
It's not arguing.
We will continue on with the next topic.
I'm seeking to understand, Your Honor. It's not an argument.
Mr. Brooks, I'm not going to explain further other than what I have done, my ruling. My ruling stands. Now, I'm going to move on to the jury instruction. I gave the parties 2 documents.
May I respectfully reject that ruling and take exception to that ruling?
Your objection is noted.
For the record, may I request a legal and factual basis for your ruling, Your Honor?
Mr. Brooks, please don't interrupt me, okay? I give you an opportunity to raise your objections and to make your legal arguments, and then I make a ruling, and then you start in on something else. You need to give me your argument all at once. For you to interrupt me afterward is disruptive to me.
It's not disruptive.
And it's interrupting and it's disruptive.
It is definitely not disruptive.
Well, that's my view of things, sir, and what I'm putting on the record is that it does disrupt what I'm doing and the flow of what I'm doing, and needing to move on, having to interrupt what I'm doing so that I can address that once again. Please, please. I know you may not always agree with my rulings, but I'd ask that you show the courtesy and decorum that is expected of everyone, and once I make a ruling, we're going to move on. You don't need to keep objecting because your objection's already been noted for the record. I'm going to continue. We're going to look at jury instruction 152. I gave the parties 2 documents yesterday. One was the pattern instruction, which I've modified, and then one is the draft of, and Mr. Brooks, please stop. You're continuing to talk over me.
Because you're interrupting. You said I have the right to object, and you didn't let me even get to the objection.
I did, sir.
No, you didn't. I was right in the middle of it.
Your objection comes before the ruling, not after. Once I make a ruling, we're moving on.
You made a ruling before we even finished the conversation, Your Honor. With all due respect,
Mr. Brooks,
before we even finished.
That's not true. Okay?
You said I'm going to make a ruling as soon as you even started in about
Mr. Brooks, I'm not going to spend hours on end making a ruling about a jury view on something I've already decided. All right, so please, I'm asking you to stop. Stop interrupting me.
You can't
listen.
Just disregard the United States Constitution, which has a supremacy
absolutely
clause.
am not disregarding the United States Constitution or the Constitution of the state of Wisconsin.
Your Honor, are you not a public servant?
Okay, Mr. Brooks, you're starting to cross the line. You've already crossed it, but I want to keep going. I want you in this courtroom. But if you keep interrupting me and putting you on notice that you run the risk of being forfeiting your right to be present in this courtroom and continuing in the next courtroom so that I can effectively and without interruption continue with the proceedings this morning.
So again, you're holding me in contempt.
All right, jury instruction 152, has the state had an opportunity without having that letter? So the state has the ability to question you about that, or question this witness, and to look at the veracity of what your claims are here. So when I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear that just fine.
In a quiet courtroom, yes, we can hear it very clearly.
And everybody assumes that it has to be disparaging.
Once again, you're doing this tactic
because
it's
not a tactic. It's facts.
It's facts. To some other reason.
It's facts. Because I find it hard to believe that
I'm gonna
all of a sudden nobody hears what I say.
I'm going to let the state make a record of why they believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me why you believe it's...
I didn't get these pictures from nobody else. Why was somebody else...
The record will reflect you have 2 pictures that you believe were from this witness.
That I know is from him.
No, that you believe.
That I know.
All right. I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object to
that.
Let
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
furthermore,
I object to that.
I'm not
because that's a lie.
Let him
at the end of the day,
if we
don't open the door on that, no, since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much.
Once
so
again,
we can
Mr.
open
Brooks
the door on.
is being
We can open the door on how old she told me she was when
interrupting.
We met. We can ask that question
he is
too. Then
over the top animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state finish.
No, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter, and he can show it is inadmissible, she will not be questioned, and under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
Mr. Brooks, you are advised to stop with the commentary.
No, I'm going to say what I want.
You called this witness. I'm going to take a break right now and excuse the jury and this witness.
All right.
What you doing is judicial misconduct. Judicial misconduct. But you don't want the jury to hear the truth. That's not fair to the jury. They have a right to hear everything.
not finna sit here and let you fix the trial because you don't want to tell the truth to the jury.
Mr. Brooks, please stop.
No, there ain't no please.
You are
nothing.
being disruptive.
Ain't
You
no
are being
please, nigga.
disrespectful.
You always
The
gonna
witness
find
may
some
step
reason to
down.
say somebody's being disruptive because they want the truth to be out there. Man, quit it. You supposed to be the
Mr.
judge.
Brooks, I'm advising you that continued interruptions will result in you forfeiting your right to be present
and
in this
under
courtroom.
what law and
during
fact can you do that?
Illinois versus Allen.
Okay,
sir.
but the fourth option that you made up, that's not even in the law,
Mr.
because
Brooks,
you can't do that.
I need to make a
By law, you
ruling.
can't do that.
I need to
And
make
you
a
know you
finding.
can't.
All right, I'm going to excuse everyone. Mr. Brooks is being removed from the courtroom. He will continue in the neighboring courtroom. Please make sure he has his objection signed and a pad of paper.
So is that
he can.
so is that holding me in
meaningfully
contempt?
participate, and I will make a ruling when I.
So are
after
you
we
holding
come
me in
back up.
contempt? Is that civil or criminal?
2 in each morning or afternoon, 3, 4, whatever. Use your best judgment on that.
Yeah, I don't know how I'm gonna come up with exacts on that.
I presume you're going to prepare some questions and you might be able to kind of gauge how quickly that will go or not. If not, we'll do our best, but you've got to provide some definitiveness. It's not reasonable to just have these witnesses all come on one day.
I'm informed of what you're saying. I just feel like that same courtesy wasn't afforded to me by the prosecution. They didn't have to tell me exactly what witnesses was being called on what day and all this and that. Why is it not even
I am requiring it, sir, because they are assisting you, because they graciously agreed to do that because you are representing yourself. If you want them to be out of the loop on that, then I can just put it on your responsibility and your shoulders. But that is up to you.
What do you mean by put it on my shoulders?
You can contact them.
How am I supposed to do that?
You have access to a phone in the jail.
So I'm supposed to call everybody that I subpoenaed, not knowing their information?
That is one way to do it, sir. Their information is in the police reports.
That is highly unreasonable. When one person that's on my witness list, I'm not even permitted to have contact
That
with.
would be a good exception to that. So that's very astute of you to point that out, sir. That would be one exception. But other than that, in any event, sir, we're kind of a bit off track. We're going to get back on track, and you need to provide the information that's provided, that I've outlined here today.
I don't think that's fair, Your Honor.
Oh, your objection is noted, but it's my ruling.
The state didn't have to do that, but I have to do that.
Sir, I remind you that you are nonetheless required to follow the rules of procedure just as any attorney would have to if they were representing you. You've chosen to represent yourself. The state has graciously agreed to assist. They've served the subpoenas on your behalf. They didn't have to do that, but they did. They've agreed to contact the witnesses throughout so that a better idea can be provided to those witnesses as to when they need to testify. They're simply asking for some basic courtesy so they can then relay that information to the witnesses you want to call in this trial.
I'm informed of that, Your Honor, but...
All right, then let's move on.
That's actually under the confrontation clause in the Sixth Amendment. I should be able to have the right to have witnesses subpoenaed. It shouldn't. Why is that?
Again, we're getting a little far afield here, sir. Subpoenas were provided to you. The record is very clear on that. We assisted you with that. I even reviewed them for completeness. And then the state assisted you with serving them. That is something they are not required to do, but they agreed to do in this case. So nothing about your Sixth Amendment has been violated in that regard.
Did I say violated or did I say I'm not?
So you need to understand that, sir.
I don't understand anything. And for the record,
All right.
I didn't bring up the word
Let
violated.
us continue then. We're going to move on, Mr. Brooks. Let us continue with the questioning
So we're going to move on to subject matter jurisdiction that has yet to be proven?
Detective Carpenter, you can please come on back up to the witness stand, and Madam Clerk, you can have the jurors brought out.
So we're not going to address that at all? That's not going to be proven for the record? Is that a judicial determination that you don't have to answer the question, Your Honor? Is there also a tactic agreement?
The state would move Exhibit 82 into evidence at this time.
All right, you want to do that in front of the jury or just with me?
I wasn't sure if the defendant would have any objections that would need to be heard off the or outside the presence of the jury.
Well, can you have them hold for a second? Do you have any objection to Exhibit 82?
Yeah, I got objection.
What's the objection, sir?
What is the relevancy of Exhibit 82?
82 is your interview with Detective Carpenter and Detective Stern. Your objection is to relevance? Your objection's noted, it's overruled, and I will receive Exhibit 82.
The court will let the jury know that when they come
So
in.
are
Yes.
you overruling the fact that the true nature and cause has not been presented to me, that I don't know what the true nature, Your Honor?
You asked the question, he answered it. If you want to limit, ask leading questions and direct him. That is your right. During cross.
You made reference to the house where the detainee was found, the grass, the city. Could it be possible that that's where they were found? The items that you are referring to?
No.
Even though it would be fair to say that you were not present.
Correct.
You made a lot of reference to the body pain and having to be checked at the hospital and being medically cleared. Would that be fair to say?
Yes, we took you to the hospital for clearance.
Are you yourself a doctor or have any training in the medical field?
No, sir.
So it'd be fair to say that you cannot know how a person's body is feeling. Would that be fair to say?
I can't explain exactly what another's body's feeling, correct.
So it'd also be fair to say that there's a possibility that you can be incorrect about assumptions made to pain reference. That'd be fair to say?
I think that depends on the circumstance. In this specific circumstance, you told me...
The last follow-up if he wants it.
Okay.
Next questions.
You made a reference on one of the exhibits. I'm not sure exactly which one it was. It was the first interrogation in the police holding room in the hospital. In that exhibit, you made reference to the FBI being present because you were short-staffed. Do you recall that?
I don't recall exactly what I said, but I recall acknowledging their presence, yes.
And you made a reference to short staff. Can you explain what does short staff mean?
I don't recall if I said that or not.
I don't know if it's exhibit 172 I'm referring to. Can you pull up exhibit 172, please?
You referring to the photo of the identifiers and the items found?
Is that
It's
172?
172, yes.
Well, I don't think, is it 81 then I'm referring to?
81 is the audio recording.
Okay, it's
I'm
81.
sorry, 81 is the video and audio.
Of the,
Was it just the audio? I was right the first time. It's
okay, I think it's 81.
You would like the audio recording from the hospital.
Yes, Your Honor.
Is there a part you'd like to direct the state to when they pull it up?
Because it's the audio, I'm assuming it'd be probably as soon as the defendant is brought into the room.
It was played starting at 4 minutes and 25 seconds through 14 minutes and 25 seconds. Do you want it started right at 4:25?
Yes, Your Honor.
Okay. The state would please assist with that.
How long would you like it to be played?
Do you know how long you want it played, or do you want the whole thing? The same clip?
I don't need the whole thing played. From what I recall, the point that I would refer to is pretty early in that.
Well, how about we start at 4:25 and then you say pause, please, when you want it to be paused by the state.
Okay.
All right, go ahead.
See right here, Darrell. I'll go grab you. I'll tell you. Tight.
Darrell?
Yes, sir.
Hey, Darrell. I'm Jeremy Wojciechowski. I'm the FBI.
FBI.
Yeah.
FBI.
I'm Mary. Yep.
They're just kind of helping out because we're so short-staffed tonight. So,
Thank you.
It's paused at 4 minutes and 56 seconds. Go ahead.
Like,
I'm not going to have this commentary, okay? I'm done. The jury's coming out. Be prepared to call
So
one of the
that's a
three.
rush to judgment.
That is not a rush to judgment.
It is a rush
Again,
to
I'm done.
judgment.
The jury's
It's
coming
clearly
in.
a rush to judgment if I'm telling you that I don't have the
No,
file.
in
How
my
am I
opinion,
supposed?
you're attempting to delay. So
No,
let's
I'm not.
keep
I'm not
going.
attempting to delay nothing. You want to come check the boxes yourself? You always trying to pull some fast maneuvers.
Mr. Brooks,
And Miss Judge, Your Honor.
Mr. Brooks, the jury's coming in.
Yeah,
Show
and
respect to
they
the
deserve
jury.
to know this too. It's still issues that need to get addressed. We didn't even address everything.
Mr. Brooks, I addressed all of the issues.
No, I
You
still
know
had
it.
another one that didn't have nothing to do with nothing we just talked about.
All
There
right.
was a whole nother issue that needed to be addressed that I needed to
And we'll
bring on
address
the
it
record to
later.
your attention.
We'll address it later.
It needs to get addressed now before we go any further because it's an important matter. Just like the subject matter jurisdiction is important. That hasn't been proven on the record.
Ladies and gentlemen of the jury,
Just
this
like
is
the
not
rush to
the
judgment.
time for evidence to be presented or arguments to be made by the
I
parties.
can't
The
even
jury
present
will
any evidence. You won't let me even put
disregard
any evidence in the record.
all of these statements
is a
made
rush to
by
judgment.
Mr. Brooks
That's
at this
unfair.
time. All right.
That's unfair what
The
you're
court
doing.
will address legal matters outside the
Then we
presence.
need to
Everyone
address
can
the
be
legal
seated.
matter that I was trying to get to before
And
you
you
rush
may call your
everything
next
out.
witness, sir.
I'm not calling any witness until I get an answer, Your Honor. You're a public servant. You're
Mr. Brooks,
supposed to be able to answer simple questions.
Mr. Brooks,
if I'm saying I have to bring
call
it to
your
your
next
attention,
witness, please. That's the stage that
I have
we
to
are
bring
at.
it to your attention, Your Honor.
Mr. Brooks,
I'm merely seeking
please
to bring
stop.
an issue to your attention.
I'm telling you to please. I'm asking you to please
And
stop.
I'm asking you,
because
can
we
we
have
address-
the jury present.
I'm asking
and
you-
we need to continue with the evidentiary phase of this trial. Call your next
I'm
witness.
asking you to address a legal matter, as you said that those have to be taken up outside of the jury.
I will
There
do
was
that
a
at the
legal
next
matter-
break.
There was a legal matter that needed to be addressed beforehand,
I
so
will
we
do
don't
it-
have to take up time,
I will do
valuable
it at the
time
next break.
afterwards to address something that needs to be addressed now. That way,
Mr.
the
Brooks,
court and you
for the
yourself are
third
on
time,
notice.
I will address it at the next break. Call your next witness, please.
Are you asking me?
I'm directing you to call your next witness.
Your Honor, we're not going to move past this, seeing as how you took an oath to protect the Constitution. I have your oath. I have a copy of your oath right here. The oath that you took, Your Honor.
Mr. Brooks, I'd like to continue with testimony.
Sir.
We have witnesses waiting for you. Please call your next witness.
The oath that you swore to protect the Constitution, which you are now not doing.
Mr. Brooks,
So you're going
call your
against
next
your
witness,
sworn
please.
oath. You're going against your sworn oath.
Mr. Brooks, call your next witness.
As you notify the jury every time when there's legal matters, we take them outside of their presence.
And we're going
I
to take
didn't-
testimony right now. Call your next
I merely
witness.
seek to put you on notice, on the record, for something that needs to be brought to your attention
And
and
I
to the
will-
court's attention.
And I will address it
That's
at the
what
next
I'm
break.
merely seeking to do. It's something that shouldn't have to wait because it'll take up valuable time later.
At least if I notify you right from the onset, you'll already know what we're looking at, and we can nip it in the bud before everything starts to roll. And
Mr.
then
Brooks,
it gets
I will
overlooked.
address it at the next break. If you want to write something down, that's fine, and give it to my clerk. I have nothing in writing. I know there's witnesses available and ready to go. Call your next witness.
Your Honor, Your Honor, you have to answer this question. You're
Mr.
making a
Brooks,
judicial determination.
Call
to
your
rush
next
me to
witness,
judgment.
please.
You're rushing me to judgment, Your Honor.
There's no rush to judgment.
There is
here,
a rush
sir.
to judgment. If you won't address a legal issue that I informed you that I had some legal issues that needed to be addressed before you just run right past that, Your Honor. You're a public
Mr.
servant.
Brooks,
Are you not a
it is
public servant?
9:37. Call
It is
your
8:37.
Sorry, 8:37. You're right. Call your next witness.
Your Honor, you're rushing me to judgment.
There's no rush to judgment. Call your next
We
witness,
had
please.
a legal matter that needed to be addressed, and I'm merely trying to
And I'm
notify the court.
Telling you
at
I'm
the
denying the
onset-
request to address it at this moment. Call your next witness.
You said what?
I'm denying your request to address it at this moment. Please
How
call.
how can you deny
please
something that we're supposed to do before
Mr.
the jury
Brooks.
even comes out?
call your witness.
I'm not seeking to be disruptive. I'm just seeking to understand why we do this
Everyone
every day.
is in the courtroom waiting for you. Please call your
Your
next
Honor,
witness.
we do this every single day. We've done it every single day. So I'm simply trying to make sure that the court is notified of
Put it
things
in
that need to
writing,
be
hand it to the
discussed.
bailiff, and if I deem it important enough to interrupt the witness, I will, but call your next witness.
How can I call a witness and write something down and do
You can
both?
take a minute
This
to
is the-
write down what it is.
This
I'm
is
not
the
asking
reason
you
why
to...
it needed to be addressed beforehand.
Mr. Brooks,
That way
the
it
jury
doesn't
is
become an
remaining in
issue.
this courtroom. Call your next witness, please.
Your Honor, you're rushing me to judgment.
There's no rush to judgment, sir.
Are you not a public servant, Your Honor?
Mr. Brooks,
Do I not have your oath of office?
under
3 of them?
906.11, this court has the authority, as you know.
Do I not have?
Call.
Is this not a copy, or I asked for certified copies that you said on record that you would not provide for no good reason? That these are three
Sir,
of your
you are
oaths
doing this,
right
and I've
here.
repeatedly told you, you can see the juries here.
You're
You're
doing-
doing this.
Listen,
we
Your Honor,
need to go
I'm
forward.
I'm not attempting to delay the proceedings. I'm not attempting to be disruptive. I'm merely trying to notify Your Honor in the court for the record beforehand. That way, everyone's at least on notice of the issues that need to be taken up, instead of waiting until a break or a lunch and things of that nature, which
In
kills
my
valuable
discretion,
time.
it's my authority. It's the courtroom that I'm
Your Honor,
presiding over. I'm not going to address
is
that
this-
at this moment.
is this not your
And
oath?
I'm not going to answer
Did you not
questions.
swear as a public servant that you will protect the
Mr.
United
Brooks,
States Constitution?
call
Did you not do
your
that?
witness.
3 times. I have all of them. Here, your oath, Your Honor, as a public servant. And
Mr.
now you're
Brooks,
rushing me to judgment
there's no
when
rush
I'm
to
doing
judgment.
things lawfully by trying to notify you and notify the court of issues that need to be addressed
Mr. Brooks,
beforehand.
we
And
are in
these
the
were issues-
evidentiary phase of this trial.
Your Honor, you're
Call
rushing
your
me to
next
judgment.
witness.
You're rushing me to judgment, Your Honor. And I object
I'm
to
aware
that.
of 3 witnesses
I
who are
object-
here.
I object
Call
to
one
that.
of them, please.
Your Honor, I object to that.
Your objection's noted.
And
for the
I
record.
want a legal reconsideration of your ruling. If not, I reject that ruling and take exception to that ruling.
I understand.
I request a legal or factual basis for your ruling, a written judicial finding of fact and conclusion of law for your ruling. And if not that, an interlocutory, declaratory appeal for this matter. And if not, these need to be stayed until this matter is before a adjudicated court of competent jurisdiction. Because we have not proven jurisdiction in this court as of yet. Subject matter jurisdiction has not even been proven on the record, Your Honor. I don't even know the true nature and cause of
Mr.
the charges
Brooks,
against me. I don't even understand that part
I
of it. I
understand
haven't
your
been
request.
provided a complaint. I haven't. Your Honor, there's so many issues.
Mr.
and
Brooks,
I'm not
we will take-
I'm not attempting to
Mr.
be
Brooks,
disrespectful in any way.
we
I'm
need
not
to
attempting
continue.
to delay the proceedings.
Your
in any
requests
way.
are denied.
Your Honor, I
And I'm going to
respectfully
instruct the
object
jury
that.
at this point to
I
disregard
respectfully
and not
object to
consider
that, Your
any
Honor.
of what has just happened since you walked in. It should not be held against Mr. Brooks in any way. These are legal issues that this court may or may not need to address, but they do not bear in any way on ultimately the issues that you as jurors will have to decide. And I'm instructing you to disregard what you have just heard and seen.
Your Honor, with everything that I just said, be made part of the record.
It's on the record. I'm telling the jury that it shouldn't affect anything that they're doing in any way.
Your Honor, it's a rush to judgment.
Mr. Brooks.
Because, Your Honor, I just showed your oath that you swore it took. You swore you
Mr.
did
Brooks,
this, Your Honor.
please call your next witness.
You took these oaths of offices. You did, Your Honor, 3 of them.
I understand my oaths,
Which is
sir,
very,
very
very
well.
commendable that that you decided to be a public servant in these type of matters, Your Honor. I respect it to the fullest, but also you have to uphold these oaths. That
All right,
you
I'm going to have
took,
to
Your Honor.
excuse the jury since Mr. Brooks is
have
not
to-
calling his witness.
you
We'll
have to-
hopefully
you have
bring
to-
you back out shortly.
You have to
All right.
honor these oaths of offices. You have to, as a public servant, Your Honor. I respect you being a public servant. And this is not to take a shot at you in any way, but these
Mr.
issues
Brooks,
that I have,
stop. Please
they
stop.
need to be addressed. They need
I'm
to be.
excusing the jury. Can you please stop?
Your Honor, this is a rush to judgment. This is a clear bias.
Mr. Brooks, you are to stop talking.
Are you asking me?
I'm advising you, or you will forfeit your right to be present in this
So you're holding
courtroom
me
for
in
the
contempt?
questioning of your first witness.
Because you're holding me in contempt.
I'm not holding you in contempt.
Then how can you remove me from the courtroom when I haven't given consent?
Mr. Brooks, I'm
can you
advising
do
you
that?
at this moment to call your next witness, or you will forfeit the right to call these witnesses.
You can't take my
Under
Sixth Amendment
906.11,
right.
you are
cannot-
refusing to
you
call
cannot-
a witness.
I didn't refuse anything, Your Honor, and you can't deny me my Sixth Amendment right, which is
Mr.
to
Brooks,
call
do you want to
witnesses,
be present in
which
this
is to subpoena
courtroom
witnesses.
while you question your first witness? Because it is now 8:44, and you've consistently talked in front of the jury who's no longer in this courtroom on issues that you have been advised and are fully aware are not relevant to their determination, despite what you believe the law
this didn't have anything
is.
to do with the jury,
Subject
Your Honor.
matter that is what you referenced in front of the
I
jury,
referenced
and then you
that
referenced
after I
my
had
oath.
raised the issues that I was
Subject
trying to
matter
raise.
jurisdiction, as you know, is not
As I
something
don't
the
know.
state has to be. The
It
state
has
must
to be
prove.
proven. It has to be. And
You are
if it doesn't,
frankly
show me
confusing
lawful law.
civil
Show me lawful
jurisdiction
law,
in
Your Honor.
federal cases with criminal court jurisdiction in the state of Wisconsin.
You don't have criminal.
That
you
has
don't
been
even
made
have.
abundantly
You don't
clear.
have subject matter jurisdiction or personal jurisdiction.
Mr. Brooks.
Or personal jurisdiction. You don't. You haven't proven.
You have not.
You
I
haven't proven
excuse
for
the
record.
jury. I'll give you the opportunity to raise whatever issue it was, but you need to do it now or we're moving forward.
That's what I want to do. That's what I was attempting to do.
And if you interrupt me one more time, you're going to go do it from the other courtroom.
And
because
so
you're
you're
being
holding me in contempt?
all right. He can go to the other courtroom and we will address these issues because
holding
you
me in
are
contempt?
not being respectful. You are disruptive. You are interrupting. I will give you one more opportunity. Don't interrupt me again. Don't roll your eyes at me. Don't sigh at me. You have delayed these proceedings now by 15 minutes because of your nonstop commentary. I'm going to sit down and I'm going to listen to you. What issue do you want to raise, sir?
So are you letting me make an offer of proof for my appeal?
No, because that's not what's relevant at this time, sir. If you don't need to make an offer of proof. Tell me what the issue is. You said
Okay.
you have a legal issue you want to raise before we get going. What is that issue?
Okay. The legal issue is this. Detective Casey yesterday testified for the second time under oath in reference to exhibits 13 and 14 that showed the backyard of my mother's home, which he stated that he had been to the home, had seen the backyard, all this stuff, when he did not, in fact, even speak with my mother. It was brought to my attention that my mother, in fact, never spoke to any law enforcement from Waukesha.
Would you like to add her to your witness list to call her?
Yes, I would.
All right, that's
because
fine.
she's
That's
willing,
how we'll
she's
address
willing
that.
to come.
But that's not something we needed to address this
It needs
right
to be
away,
addressed
sir.
because of the issue of the subpoena. That's the reason why it needed to be addressed. That's the reason why I was trying to attempt to
It
bring
could
it
have
to
been
your
done on a
attention.
break. All right, so
Will I be
You're
Because I
putting,
have-
you're asking me to add Dawn Woods to the witness list for you.
Yes, but I also have a question about the subpoena
The subpoena for whom?
for my mother. But I would also like to subpoena the phone records so it can be made part of the record of the conversation, since the prosecution listens to all the phone calls. They should be able to have heard that phone call as well. So they should be on notice of what was said.
I don't know what phone call you're referring to. If
I'm
you're referring to a
phone
jail
call
phone
from-
call,
I'm referring
then
to a jail phone call that was made last night, October 20th, between 7:54 p.m. and 8:10 p.m., which I'm sure the prosecution has heard by now. And that also brings up the issue of perjury testimony.
sir, the way that you will address the issues that you're talking about are to call witnesses to challenge that or to present the evidence in support of your position. If you're telling me you need to add Dawn Woods to the witness list, I approve of that. You can fill out a subpoena and I'll direct the state to serve that upon her, and at the appropriate time we'll have her brought, we'll indicate when in the order of folks she can be brought in. So I'll grant that request.
Will I be
In
able
terms
to,
of the jail records, you'll have to subpoena the appropriate custodian or a witness who can testify to that.
that's what I was trying to gain knowledge of. Because
Well, I can't give you advice on that,
I'm
sir.
not trying to ask for advice. I was is that
That's
legal for
asking
me to
me
subpoena?
for, I can't direct how you do that. I can't tell you how to do that. You are acting as your own attorney and you will need to figure that out. So you have the subpoena forms. You can research the issues. You have access to legal research materials and other things. And that's how you'll have to address
I
that.
accept for value in return for value this document.
Was that a subpoena form? It is. Thank you. Is there any other witnesses you're asking to add to your, and you can also call Detective Casey if you want, just so you know.
So that make 3 times he's able to testify?
If you believe he has information that he hasn't testified to, I will give you permission to call him as well.
No, I don't think it'd be necessary. He know what he did.
Well, in any event,
And he know what he didn't do.
we're going to bring the jury back out, and then I expect you to call a witness.
And just so I'm clear, because I was trying to get to that issue, what witnesses are here? Because I don't have any paperwork for Kohler. I don't know. how to
Douglas
pronounce
Kohler, Stephen Guth, and Erica Patterson. Of those 3, I expect you to call one of those witnesses.
it. I accept for value in return for value this document.
For the record, Judge, Attorney Witchow just handed to the defendant for his benefit the police report as it relates to the statement of Douglas Kohler, since he's claiming he does not have it.
Since I know that I don't have it. So let's make that record correct.
You don't have it with you in the courtroom is what you're saying.
I can't find it anywhere.
You've had it previously.
Yes, I had it at one point.
All right. Are you ready to proceed forward, Mr. Brooks?
Yes.
All right, let's bring the jury out. Thank you, everyone. Please be seated. Mr. Brooks, just to make sure, don't block any of the microphones with anything. Both of those microphones should be on. You want to make sure that. Thank you. All right, go ahead, call your next witness.
Yeah, the defense calls Douglas J. Kohler.
All right. All right, thank you. Be seated. Mr. Brooks, under 906.11, I do have the authority and just my inherent authority over this case to require you to call the next available witness. You, in my opinion, were not entirely cooperative yesterday with the process, and so I told you that 3 witnesses would come in at 8:30, 2 would come in at 10:30, 2 would come in at 1:30, 2 would come in at 3:30, and then if there were any left, I wasn't sure if there were or not, would come in at 4.
You also didn't provide me with that list.
You were advised on the record,
But
sir.
you didn't provide it to me.
Sir, you chose not to write down. So that's on you, not me.
Nah, that's
So
no. You
here's
can't.
the
That's
thing.
a rush to
Erica
judgment.
Patterson is here, so I'm advising you that she will be the next witness that you call if you so choose. If you choose not to call her right now, then I'm releasing her from the subpoena because we have almost 45 minutes until 10:30, just slightly under that. And there's no reason for you not to call her.
Yeah,
She's
the
on
re-
your list. She was on the listing as I understand it, the groupings of 3, Tuesday
That you
morning,
understand it.
Tuesday afternoon,
Did you
Wednesday
receive it?
morning, Wednesday afternoon, and so on and so forth. That's the order. I told you very specifically I'm not going to have everyone come in at one time because that's not efficient, that's not effective, and it's not courteous to them. People have families, people have jobs and other responsibilities, and we're trying to be mindful of all of that as well while having the state assist you in getting these people here. So I'm advising you that if you don't call her right now, you will forfeit your right to call her.
Is that lawful law?
Sir, I believe I have the authority to do that. She's here. She's ready to go.
I'm just
She's
asking
your
the question.
witness.
I'm just asking the question. Is that lawful law?
I have the authority under 906.11 and other rules and the inherent authority of this court to control the order and mode of interrogation
Your Honor,
of
why
witnesses.
is it always so hard to just say yes or no?
Yes,
Is it lawful
I have
law?
the authority, sir.
I'm not disputing that.
You just
I'm not
disputed
disputing.
that.
No, I asked the question. Is it lawful law?
Sir, I've told you what I believe my authority is. Okay,
You
if
told
you don't
me
want
what
to
you-
recognize it,
you
that's
told
fine.
me
You
your
want to
authority.
object and note it, that's
You told
fine.
me your
Your
authority.
objection
I'm
is
not.
noted
I'm not
on the
debating
record.
your authority. I'm not.
So I will address one other issue with you because you said you had an issue regarding the last witness, which is fine. We can address that quickly, and then I'm going to have the jury brought in, and that will be your opportunity to call
That's a
Ms.
misdirect.
Patterson.
That's a misdirect. What issue did I said I had with the
You
last?
said you wanted to raise
said-
an issue with about
What
Detective
I said
Guzman's
was
testimony.
I might have more questions for that witness. I didn't say it was an issue.
Oh, I didn't hear that, sir. You had your opportunity to ask the witness questions. He's been released.
Your Honor, if I mumble something under my breath, somehow that's audible, but when I talk clearly, somehow
I may
nobody
have
hears
missed
me.
it, but I heard what I interpreted was when you said I may have an issue with this witness. I didn't understand. I guess I didn't take that as you were going to reserve your right to recall him. Are you telling me you'd like to reserve your right to recall Detective Guth?
Yes.
All right, then that will be noted, and we'll keep him under the subpoena. Now, that should address that. I'll have the jury brought back in, and you should be prepared if you choose to call Ms. Patterson. This is your opportunity to do it.
At the same time, though, that's still a rush to judgment, Your Honor. You can't. I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses.
You did not want to provide us with the order, and I respected that, Mr. Brooks.
But I said that.
And
from the
so
beginning.
then I asked
Your
you
Honor,
to put
with
him
all
in
respect,
blocks.
with all respect, did I not inform Your Honor in the court that I would not give a specific order? I stated that numerous times.
And Mr. Brooks,
Numerous
I
times.
have authority to tell you otherwise. You
I
may
did.
not like it. You may
I did.
disagree with it.
It's not
You
about
have
that.
been-
It's about the rush
you
to
have not
judgment,
been
Your Honor.
cooperating with this process. The
There's
state
nothing
has
to cooperate
graciously
with.
agreed to assist you given your custodial status.
Okay, and I never asked them to
frankly,
do
any
that.
attorney in this
I
situation
never asked them to do that, Your Honor.
would give us the order.
Did I not? Did I ask them to do that? I did not ask them to do that. They
No,
volunteered.
They offered.
So at the end of the day,
but we expect
If
your
they didn't want to do
cooperation in
it,
that.
yeah, but that wasn't one of the stipulations when they offered to do it, Your Honor. Let's
No, common courtesy is the stipulation.
okay,
sir.
but it
And-
wasn't
and here's the
stipulated
thing.
to, so I didn't have.
You are well advised of how this process was going to go.
No, I was not.
It is
because
normal
if you
in a trial
you can't
to call
put the people
witnesses
you can't
out
put the
of
people
order
in a
based on
specific
their
spot for me,
availability.
Your Honor. Come on now.
That it is.
That's a rush to judgment.
There's no rush to judgment here. You
Did
keep
the
saying
state
that, sir,
have to
but
put
that's
their
not the
witnesses?
case.
Your Honor, with all due respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did.
Did they have to do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did not.
I didn't have to be
do it.
provided with. We're going to call this witness at this time,
But they're
and this
able
witness at this
to
time.
contact
They
their
didn't have to do that, so why should I have to
and
do that?
accommodate their schedules. This is not about you. It's not about the state. It's about the witnesses'
It's about what's fair.
availability.
It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this court.
How am I controlling what's happening? I'm the one shackled to the table with
here's the
with a
situation.
shock device
It is
on my ankles.
9:52.
So how's I'm trying to control anything?
I'm having
I just
to-
want this
I'm
to be
going
fair,
to-
and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't have to do, how's that fair?
It's fair.
Explain to
because
me how
of
that's
the
fair.
process that has been set up to, frankly, help you. get
No,
the
it's
witnesses
not helping me by
to
it's helping
court.
the state
And no.
by being able to say if we know the time and we know
You
the
did
person
not-
and
I
we know this,
asked you-
then we can be prepared. So we'll already be ready.
Mr. Brooks,
That was
I
the
asked
whole
you
aim of that.
yesterday, and I would have had her come in later. You didn't want to answer that question.
There was no
And
question. There was no question to answer.
That's not
I
true.
did what you asked me to do, Your Honor. You
No, you
said
didn't.
yes, you did. You did. You asked me to give them my witness
Mr.
list.
Brooks,
I gave them my witness list. It's not my fault.
I very
It's not my fault they
expressly-
weren't going to be prepared to
Mr.
do
Brooks,
their
here's the
to
deal.
do
The
their
jury's
cross.
coming out, and I'm going to stand my ground on this.
I'm going to
Okay,
stand my
it
ground
is-
too, but I'm
if
not
you
going. I'm not
don't
going to
call
be
her-
disrespectful or disruptive.
If you
I'm just
don't
stating I
call
wanted to be
her
fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that.
For your
Where's
lack
the
of
lawful law?
cooperation.
Where's the lawful law? I have the right to
You
witnesses,
have to cooperate with this process.
but I
sir.
also have the Sixth Amendment right.
We have a witness available for you to call. I can require
It's
you
not
to
the
call
witness
her
that
right
should have
now.
been called at this time, Your Honor.
It is based on the list that you provided and
That
in
didn't
the
have a
order.
time. That didn't have a time or of
I'm not going to
or an
play
order.
this game with you, sir.
It's not no game.
It
That's what
was-
you don't
it
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game.
We.
I don't take this as a
asked-
game. That's what
me
nobody.
explain this to you
That's what
once
nobody.
again.
You don't got to explain nothing to me.
Do you want?
That's what you don't understand. You think
you
that
want
this
the
is a whole
opportunity
game
to
to me.
question?
This is not a game to me, Your Honor. Nothing about this is a joke.
I never
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
And it's
some things in the
unfair.
ship
It's
that's going on.
unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a
What
joke.
type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So,
And I
so I
understand.
think, Your Honor, with all due respect, I think you
So
should show
we're
some
going to take
respect.
a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in recess.
No, you're not rushing me to judgment. I don't care what you're talking about.
I'm going to excuse the jury. I'll rise for the jury. Thank you. Be seated.
It's awful funny. Your Honor, I find it.
Hold on. All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is...
the letter
hold
too?
Hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying, and then also by what's the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you sneak and have
Do you want
contact?
to open up the door to the other act's evidence of
That's
you
not
use-
opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts evidence between you and this witness. And I have been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or why she wouldn't have contact or not, you are opening the door to that testimony. All of my rulings have been made to prevent what could be seen as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial. But you can open the door to that, sir.
It's unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness can get on the stand and lie on the stand.
Over to the state.
Come on, man. Y'all know that's not right. Y'all know that's not right.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When did you receive the document? Hold on. When did you? I'm having you make an offer. When did you receive the document?
Okay, but I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
that's not true. That's a misstatement of the evidence.
That is true.
No.
She said it herself.
No. Marking an exhibit is not creating an exhibit.
No, not marking an exhibit. She said
we're not going to go down a tangent, sir.
Right,
I'm going to focus on this, and I'm going to give you the opportunity to make a record.
It's not fair. It's not fair.
When did you receive this document that you claim was sent by this witness?
It's not claimed. It's for a fact.
Sir, it hasn't been established yet. I need to make a record.
So do y'all want
the
letter?
I want to see the letter.
What?
I want to see the letter.
Okay, so I got to.
And I want to know when you received it.
I got to bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. but the state can do it no problem.
It's not, sir. There are proper procedures, and I
Okay,
want
well,
you to
that
make
was the
a
proper
record.
procedure.
If you don't make a record,
So
then
what?
I can't make a ruling.
It threw people off the loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
aren't
it.
you aren't
Stop
even
it.
letting
You're a
me
public
ask the
servant, Your Honor.
questions.
I respect your courtroom. I
You
respect
do.
you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what
This
he's
is
referring
ridiculous,
to
man.
in count 77. Okay. The
And what happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make
be
a
found.
record of a variety of
So who
things.
took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly,
Okay,
sir.
whatever.
So you're doing it once again.
Whatever. Just make your record.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My guess
Your Honor,
is maybe
with
to
all respect-
simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
And I've been trying to find it ever since I came back in here. And now all of a sudden I can't.
And now
find
you're impugning, though, like somehow you're impugning the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the assumption that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record without
Yes,
you interrupting
yes, you may.
me?
Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't
You
say you.
implied it, sir.
But did I say that?
You stated it implicitly.
I never asked the bailiffs, hey, did any one of you touch my table? I never said that to them. I just said I can't find my paper, which is the truth.
And the way that you said it, like,
I didn't point anyone out, though.
And like,
I
well,
don't
that's
think that
kind
that's
of
fair.
interesting.
I don't
I don't
think that
have a
that's fair to
document that was
assume.
just on my table. That is what you said.
That's
Words
what
to
I
that
said, but I
effect.
did not point the finger at anyone.
So,
I
you
can see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I would have directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue with the record, sir. It's very apparent to me, sir, that every time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, When the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you that was not in your favor, that you start peppering me with questions or comments, statements, you question me about the law, you ask is it verified law. It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing, perhaps even to stall and to delay.
I'm sorry
That's
you
my
feel that way.
that I'm making a rule. You're doing it again.
I mean, because it has no validity.
So, I am trying to make a record outside the presence of the jury about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a witness. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness who's testifying. All right, then there's the statute on bias, 90616. All right, and none of the questions as I heard them went to a permissible topic under bias of witnesses. You generally said credibility. You did not give me any further explanation as to why you believed it was relevant to credibility. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. I think, and you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't, I referred to this one because this one had the pictures. But
and why do you believe it was from Ms. Patterson?
To answer your question with clarity.
Thank you. Does it have a date on it, the letter?
No, I didn't bring the letter, I brought the pictures. Because I thought, from my interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air. The witness knows that they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing, and oh, this and this and that. Oh,
I don't think she's ever said she was afraid. I think that was the officers who may have stated that, but I don't believe she ever said that. She specifically said today when you asked her why did you, it was either why did you go back or why did you have, I'll look at my notes, and she said, I don't know.
It was why weren't you forthright with all the details? That was the question.
So again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it relate to her credibility before the jury?
Who else could these pictures be from?
I'm going to ask you point blank. Did you get a letter that's signed from her?
I got. What do you mean signed?
How do you know? What's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was it the content of the letter? No, I'm not kidding you. I need to make a record, sir. making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm gonna go out on the limb here.
And I'm asking you why you hold that opinion.
I'm gonna go out on the limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. No one is gonna. When you
You're
say
not
to me,
answering my
when
question,
you say to
sir.
me,
What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying, could be anybody else. You got to answer my question. It's called an offer of proof.
But you still got to understand why this is mind-boggling to me. Like, how I got a child with this woman. Why would I not know her handwriting?
But you have to lay a foundation for these letters, sir. That might be through your own testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff about I'm in jail and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious.
Because they're from her.
But you're assuming.
Like, how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal term.
The bottom line is I need the letter. So if you're going to question her on that, the state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter. So the state has the ability to question you about that or question this witness and to look at the veracity of what your claims are here. So I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear that just fine.
In a quiet courtroom, yes, we can hear it very clearly.
And everybody assumes that it has to be disparaging.
Once again, you're doing this tactic.
Because
it's
not a tactic, it's facts.
It's facts. To some other reason.
It's facts. Because I find it hard to believe that
I'm gonna
all of a sudden nobody hears what I say.
I'm going to let the state make a record of why they believe it's objectionable because I haven't let them do that. I've given you multiple opportunities to tell me why you believe it's...
I didn't get these pictures from nobody else. Why was somebody else...
The record will reflect you have 2 pictures that you believe were from this witness.
That I know is from him.
No, that you believe.
That I know.
All right. I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object to that.
Let the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
furthermore,
I object to that.
I'm not
because that's a lie.
Let him
at
finish.
the end of the day,
Let him finish.
If we're gonna open the door on that, no, since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
So
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me
disrespectful,
she was when
interrupting.
we met. We can ask that question
He is
too. Then
over the
Did you
top,
ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No, that's
finish.
not. I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he
Don't
can
sit
show
there and try
it
to
is
think he knows what's
inadmissible,
going
she will
on.
not be questioned. And under 90611, I will
Then you gonna
declare
talk
the
about where my kids
cross-examination
live. You don't know where,
closed.
You don't know where, what
Thank
happened
you.
at
We're
the
in
time when
recess,
all this
1
happened,
hour.
bruh. Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
All right, the defense may call its next witness, please. Go ahead, sir. You can call your next witness.
I thought I was muted.
You're not muted.
So how long am I supposed to stay in here now?
I'm going to excuse the jury. We'll hopefully have you back shortly. All rise for the jury, please. All right, the jury is no longer in the courtroom. Mr. Brooks, I had the jury leave the courtroom because it appeared to me you wanted to perhaps either ask to come back into the courtroom or make another record of something. Do you want to come back into this courtroom as you call your next witness? You're not muted. You're unmuted.
So what's going on now? Why am I being held in contempt yet again?
The record will reflect that pursuant to Illinois versus Allen, Mr. Brooks was not held in contempt, although that is one of the possible ways for a trial judge to handle a defendant who is stubbornly defiant, disruptive, and contemptuous. That is not the only way in which a judge can address a defendant that is being discourteous, disrespectful, and disruptive. So pursuant to the authority in Illinois versus Allen, I found that you forfeited your right to be present based upon your conduct. I'd also direct the parties to some persuasive authority from other jurisdictions that are more recent, including People versus Cone from the state of Colorado, 160 P. 3rd 366. It's a Colorado Court of Appeals from 2007. And then from the state of Washington, from their Supreme Court, State versus Davis, 461 P. 3rd 1204. That's from 2020. And then I'd remind the parties of the district court decision that was later affirmed from Pennsylvania, U.S. versus Jennings, 855 F. Sup. 1427 from 1994. The finding was, sir, that you forfeited your right to be present based upon your conduct.
Okay, and all those case laws you just cited are pursuant to that.
Sir, I will ask you, would you like to come back into this courtroom as you continue with the calling of witnesses and your next witness?
I thought you was using Illinois versus Allen.
You are welcome to come back into this courtroom, sir.
So why was I removed in the first place then?
I've made my findings. The record will stand. I will ask you one last time. Would you like to come back into this courtroom as you call your next witness?
You're not finna hold me in contempt no more. Not finna do that.
Mr. Brooks is not answering my question directly, so based upon that, I'll advise him that if I will ask one more time and he fails to answer it with a yes or no, I will take that as a no, that he wants to stay in that courtroom.
You can't answer
Mr.
for
Brooks?
me. You can't do that. You can't do that.
Mr. Brooks, I'm advising you that I will. He's interrupting me once again.
Okay, you talking. You the one talking right now, so don't do that.
I'm going to mute him because he's not being respectful and he's just spouting off. So he did not answer my question directly. He is not reclaimed his right to come back into the courtroom because number one, he has not requested it. Number two, he hasn't answered my question about whether he wants to come back in. And number three, he hasn't stated or demonstrated a willingness to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I will give him one more opportunity so that it's abundantly clear on this record that I am honoring his right to be present, and I will unmute him. Sir, would you like to come back into this courtroom as you call your next witness?
Don't try to seem like you're trying to honor my rights now because you haven't.
Okay,
been doing
he
it before.
is again not answering the question directly.
Don't try to put on no. Don't.
I'm going to mute him again. As I've noted before, this is a clear method now that Mr. Brooks is employing, that when I've done something that he disagrees with, that he just continues to argue with me and does not answer questions directly. So based upon his continued disruptive behavior, the fact that he will not answer my questions directly, I'll find that he's continuing to forfeit his right to be present in this courtroom. Clearly the audio and visual technology are working. He's been responding, although not appropriately. He is in that other courtroom. We can see him. He does have the headphones on, and I've confirmed that he can see and hear as well based upon the court personnel that are in the other courtroom. So I'll make another finding that his appearance from the other courtroom is the functional equivalent of him being present in this courtroom. Mr. Brooks, before I unmute you, I am going to advise you, I will ask you to call your next witness, and if I don't get a direct response out of you, I may ask it again, and if you fail to give me a direct response, then you will forfeit your right to call any other witnesses. So I'm going to unmute you. Actually, I need to bring the jury back out, but before I do that, I will unmute you first and ask you which witness you intend to call so we can at least have that person ready to go and outside the courtroom. Who will be your next witness?
I'm not calling no witness if I got to be in this other courtroom.
Would you like to come back into this courtroom, sir?
Why was I ever removed? You never answered.
I've made a record of that, sir.
I have to answer everything, though. Everything you ask me, you expect me to answer. But then when I ask you questions, you never have to answer anything. I just put on the record that 2 of your bailiffs just made gestures. When I'm looking at them off the reflection of the screen, they're making gestures behind my head that make me feel uncomfortable. I just brought that up on the record. You didn't even address that.
Mr. Brooks, I didn't address it because, frankly, you keep interrupting me, and then I have to deal with the interruptions and make a record regarding that. So I just saw the captain walk over. I will let security personnel, Captain Dussault, look into that, and if appropriate, he can bring that conduct to my attention. I'd also remind the defendant that at any time you can also ask to be brought over through the bailiffs who are in that courtroom. So to be abundantly fair to you, I will ask one more time, would you like to come back over to this courtroom?
I should have never been removed.
That's not answering my question, sir.
You haven't answered my question.
The court's not going to answer questions directed at the court by the defendant because they're not relevant or probative at this time, and they're a delay and disruptive tactic. Mr. Brooks.
A delay and disruptive tactic. Is that a judicial determination that you're making?
I'm going to mute you because we're going off on the judicial determinations. Every decision I make, sir, is by definition a judicial determination. It is on the record. If there is a conviction, you can raise whatever issues you want on appeal if you are convicted. But we don't need to have this back and forth every time to further make the record when the record speaks for itself. You were given plenty of opportunities throughout this trial to make offers of proof, to state your legal reasoning for either an objection or for a question that's being asked or for a whole host of other things. But right now you're not doing anything legally relevant. You're being disruptive. I would like you to be present. That is always what I want during this case. It certainly, I think, is important, but you can forfeit your right to be present by your conduct, which you have done repeatedly throughout this case. I will advise you that if you are in that courtroom, because I have put you there and you have not reclaimed the right to be present by number one, asking, and then expressing a willingness to conduct yourself consistently with decorum and respect inherent in the concepts of courts and judicial proceedings, you will remain over there. And it looks like he took his headphones off, so I will. Mr. Brooks, I'm advising you that if you fail to call a witness, you will forfeit your right to present any additional witnesses. And I'm doing this outside the presence of the jury right now for a reason. I need to know from you right now, you are unmuted, who is your next witness?
She trying to say something to me? Yeah. What you trying to say?
That was very disrespectful, sir. You chose to take off your headphones?
Yeah,
you choose
because
to
I'm
read.
muted. I'm muted. So why am I gonna have my headphones on and I'm muted?
Well, I would think your headphones help you hear. The
They
muting
do.
is so that I don't have to hear the disruptions.
Okay, well then why should I need to hear what
So
you
let
saying?
me be clear, sir. And you
don't
are
gotta
not.
be clear or nothing. I don't gotta listen to you.
I will ask you one last time, sir. Who is your next witness?
First of all, is she talking to me again?
He.
So
This.
we gotta keep doing this little childish stuff, dude. I gotta sit up here and I'm supposed to abide by every single rule, but don't nobody else gotta do that.
The record should
Judicial misconduct.
reflect that Mr. Brooks
Repeatedly.
is spouting off, making
I think
unsubstantiated
the record can hear me.
allegations
I think they can hear me.
against this court,
Unless I'm
directly
muted.
attacking the integrity of this court and these proceedings, while yet
This court ain't got no
refusing
integrity.
to answer
This court don't have
simple
no
questions. Mr. Brooks, you
That's
are,
not my name. I told you I don't consent to being called that name.
sir, you are hereby advised this is the last time I will ask this question,
Don't talk
or
to me
you
like
will
that.
forfeit your right to present
Can't do that.
any
Show me what-
additional
show me
witnesses,
where that's law.
because
Show
you
me
are
where
not
that's law.
cooperating with this process.
Show me that it's law. That's all I'm asking. Show me that it's lawful law.
Mr. Brooks,
How can I forfeit not being able to have a defense? Are you kidding me?
all I'm asking is that you conduct yourself with dignity, with decorum, and with respect. I will
Okay.
gladly bring you back into this courtroom so you can present your additional witnesses.
You're
But
right.
you need to ask me to come back into this courtroom.
With all due respect, I'm tired of having this back and forth with you every day. It's not my intention to come in here and have these interactions with you every day. It's not. Regardless to what you may think, regardless to how you may feel, that is not my intention. Okay? I simply do what I do because I do not have the understanding. So if I don't understand something, I'm going to ask a question. I apologize if it makes you feel that I'm intentionally trying to delay the proceedings. If I'm intentionally trying to be disruptive. Because that's not the case. And I feel very disrespected every time the record is made, making it seem like that's what I'm attempting to do. So of course it's gonna frustrate. Of course it's gonna make me a little bit upset. And I just want you to understand that. It seems to me the way I'm interpreting what you're doing, which is it is your courtroom. That's not it. It's not a dispute. That's not up for debate. You control what's going on in there. That's not a dispute. But the way I'm interpreting what you're doing is that I'm being held in contempt. That's how I'm interpreting. Because one of the three things that's cited in the Illinois versus Allen, one of them is being gagged. I haven't been gagged. One of them is held in contempt.
What's the third, Mr. Brooks? What's the third?
The third is removed from the courtroom while the trial continues, right? That's the third, right?
And that's what's been done.
Okay. So now, where does it say after that that having me on a headset or being able to see and hear and all this and this, how is that not prejudicing my defense?
Sir, you can
I
raise
can't
that
even-
issue on
I can't-
appeal. You
This
can
is
raise
why I
that
say that.
issue on appeal
why I
if
say
you
that.
are
This is why I say
convicted.
that.
This is
This
why
is why I say that though,
This is
because
why
I
I say
can't
that,
even
though.
see.
'Cause
The
I
only
can't
thing I
even
can see right now when I'm looking at the TV
right now when I'm looking
is
at the
you
TV is you
and the prosecution table. I
and the
can't see
prosecution
anything
table.
else.
I can't see anything else.
I understand that, sir. I'm fully aware of that.
So I'm not fully
So
aware
I'm
of what's going
not
on in
fully
the
aware
courtroom.
of what's going on in the courtroom.
Don't I deserve that right
Don't
to
I
be able to
deserve
see
that
and
right
hear
to be
everything
able to
that's
see
going
and
on?
hear everything that's going on?
If you can conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, the answer then is yes. So, I'm not going to have a debate with you about the law. I will ask you again, would you like to come back into this courtroom?
Are you going to kick me out?
Are you going to kick me out?
Sir, I'm asking the questions right now. Would you like to come back into this courtroom? Yes or no?
Kick me out. Are you going to kick me out?
Are you going to kick me
Sir,
out?
it's a yes or no question. Would you like to come
Well,
back
my
into
answer,
this?
Well,
my answer was based on the reason
was
why
based
I'm
on the
answering
reason why
like that
I'm
is
answering
because the
like
moment
that.
I say
Because
something,
the moment I say
it's going to
something,
get me put out.
it's gonna get me
I don't
put
want to
out.
keep
I
hauling
don't
this
wanna
stuff
keep
back and
hauling
forth
this
and
stuff
back and forth and back and forth and back and forth.
back and forth and back and forth.
It makes essentially it wastes time, really.
It wastes time, really.
I'm well aware of that, sir. That it delays the
Yeah,
proceedings.
Yeah, but
But then it's laid at my feet as if that's my attempt. You think I want to be over here?
You think I want to be over here?
Sir, I don't know what you want or don't want at this time. I know that we need to complete this trial and that you have frustrated today more than ever before the ability of this court to do that.
Well, I apologize for you feeling that way, but I'm frustrated too. And nobody seems to take that into account. I'm just as frustrated as everybody. Probably more.
Then I suggest that you conform your conduct to the requirements
There
of
is no
courtesy and
conduct,
decorum
Your
so
Honor.
that you don't run the risk of forfeiting your right to be present. But
there
that falls
is no-
on you and you alone, sir.
There is no conduct. I don't understand what you mean by that. I really don't.
Mr. Brooks, you may not understand it. I don't think that's accurate. I think you know exactly what you're doing.
If that's what you think, that's fine. I can't argue
And
with
you
you
have
about your
demonstrated
opinion.
throughout this case that you pay attention to witnesses' testimony, that you make cogent and coherent objections. At times that you have even had evidence suppressed in this case or stricken. That's the word I used during this case. You made an opening statement. You communicate with witnesses. So
Your
you
Honor,
clearly
it's
read,
not
write,
fair.
and understand English. That's not an issue
not-
here, sir.
It's not fair
Are
to
you
say-
self-represented? Absolutely. Does that present difficulties and disadvantages? Absolutely. But that takes me back to when you waived your right to counsel. And you did so knowingly, freely, voluntarily, and with a full understanding of the disadvantages and advantages of doing so, meaning advantages of having an attorney, the disadvantages of doing it on your own, and you made a deliberate decision to
Your Honor, that's
represent
not fair.
yourself, and that comes at a risk to you of, yes, at times not fully understanding the law, the rules of evidence, the rules of procedure, but you do
not
so
fair.
at your peril.
That's not fair to state, Your Honor, because
So I'm going to do the
paperwork-
following. Since I'm not really getting anywhere, I'm going to mute you for the moment. I'm not getting anywhere with him. I would like him to be brought over, and he has a choice to make. He can come back over or he doesn't. Either way, he's going to be asked to call a witness in front of the jury. I will ask him 3 times if he fails to give me a direct answer, and after the 3rd time, I will make the appropriate finding, but I will do that outside the presence of the jury. But we are going to continue. So we'll go off the record and he will come back over here. Thank you. We are in recess until that happens.
I'm curious. Some of these, judging by the reports, how are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question. I'm not sure what you're asking me.
What I'm asking is, reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how. I just, to be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or fact.
It's obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis. If you want to...
It's clear.
If you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any more legal advice further than that.
I don't think I have to
So
call any other witnesses that's
if
not
you're
on the
asking me to
stand.
strike their testimony based on your
I didn't say
perceived,
anything
then that's
about that.
all right. Then I'm going to bring the jury back out and you're going to call your next witness. So I'm
So
not
is you-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask
All of a
questions to
sudden,
lay a foundation
all of a sudden the
with
state
these
don't
witnesses.
got. All of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this is
not-
argument.
Come on, man.
This is argument on your part,
I
sir.
see
It
through
is pure
I
commentary
just
at
want
this
that on the
point.
record. I see through it.
And your
Nice try,
see-through
but I see through it.
has absolutely no basis in
Well,
fact.
I know that's what's being done.
You
Come
could
on, man.
ask
I'm-
these questions. You could
Come on,
ask
man.
these
Got the right
witnesses
one.
certain questions, and
I'm
you're
far,
not.
I'm far from an idiot.
They're your witnesses, sir. If you believe,
So I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer? Because
well, you can't
I
ask
find-
that, but
I
you can
find
ask
it
them
very
if they've
funny.
met with anyone ahead of
I
their
find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with other witnesses.
I find it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach
attempt
for
by
something.
you
Oh,
to
I don't.
delay these
I don't recall
proceedings.
what they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought
man.
out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I
present.
didn't say nothing. You.
Before we do that, there's an issue that we do need to take up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be
the-
said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
to benefit
Come on, man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's be
has
clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had
Alleged
the elevator
record of
voice just for
ableist
that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.